Tax. All these tax matters, end of the list which I am saying, file should reach by 1 o'clock. File should reach by 1 o'clock. You must complete whatever office objection, clarification, etc. Tax. Give it. All advance copies must be given to Pawan Kumar. Give it. Tax matter. Give it. Tax. You. Tomorrow. Yes. Before 17th, you want. No. Tax told end of the list. Online. You move it online. Move it online. If there's any difficulty, you meet the court office. Yes. Yes. No. Just wait. Just wait.
Page 1, list number 1, page number 1, serial number 4 to 6. Page number 2, serial number 7 to 16.
10. 10. Which list? First list. Premises is sealed. Premises is sealed. And you want after 2 weeks. You come, I've seen the file. You come. You come, madam. You want relief, your senior also wants relief, isn't it? You come. You have the file? You come. Read and come. You know, when you're getting relief, you should never say no. You have to seize the opportunity.
Number 3, serial number 17 to 20.
Yes. We'll have it in first week of March. First week of what? Okay, so we'll have it in the first week of March. It's a matter of first week of March. Inform the other side.
Number 4, serial number 21 to 27.
Yes. (27) 24. Correct, it's covered. With short date next week, put it.
Yeah.
Relist the matter on 12.
Page number 5, serial number 28 to 35. Page number 6, serial number 36 to 41. Page number 7, serial number 42 to 45. Page number 8, serial number 46 to 49.
The matter, same stage on Monday.
Page number 9, serial number 50 to 55.
Serial number 55. Appear for founded things and laws of and everything.
So 11. This is
Okay.
15th or 12th.
Have informed the other side. No, 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 whatever it is. I don't want them to come and then say matter is adjourned without notice to me. Anyhow, let us see. Yes, inform the others.
Page number 10. Page number 10. Page number 56 to 58. Page number 11. Page number 11. Page number 59 to 64.
You have informed the other side. Request. List the matter week after next.
Page number 12. Page number 65 to 67.
You appear for? You have informed the other side. You have to inform. If they come and they say they're not notified, I'll take up the matter. Week after next. Week after next.
Number 13. Page number 68 to 74.
Number 70, madam. Paper petition.
List after 2 weeks. All the other council on the other side have to be informed. I don't know. That's your headache. All the council on the other side, you have to inform, or when it comes, I'll accommodate. Yes.
Page number 14. Page number 75. Page number 2. Page number 1. Serial number 1 to 4. Page number 2. Serial number 5 to 10.
Yes. First list the matter week after next. Not earlier than to extend it till the next day. Give them.
Page number 3. Serial number 11 to 16.
You have informed the other side.
I will inform now. It may post on 28.
Take, let us. At request, list the matter week after next.
Page number 4. Serial number 17 to 21. Page number 5. Serial number 22 to 27. Page number 6. Serial number 28 and 29. Page number 1 for each of the matter. Serial number 1.
Which page? In which page? In which page of the order? Which date? 24. So what is the change? Ah. The council for the petitioner moved a memo for being spoken to and submits that there is a error kept in the order of 22/1/2024 insofar as description of respondent number 5. is submitted that instead of Vemgal Town Panchayat, the words, the words Panchayat Development Officer, Khyatagatta Gram Panchayat requires to be substituted. Taking note-
It expects to not, there is a fixed date for the parents of the party.
When?
What is the, what is the date in that? Now, we are capital.
Date.
Capital. After the release.
The date also found. The date also mentioned. Requiring the presence of the petitioner before the fifth respondent, dated 31/1/2024. It is also to be substituted by the date 12. Huh?
Whatever it is,
By 12/2, by 12/2/2024. The date of hearing mentioned as 14/2/2024 is also to be refixed as 21st/2/2024. Accordingly, order dated 22/1/2024 is modified as follows. 24, that is 12. Yes,
Number two,
Yeah, actually.
your file. Pass over. Let it come.
number three, GB.
ಗೌರ್ಮೆಂಟ್ ಮ್ಯಾಟರ್ ಸೊ ಒಂದೇ ಒಂದು ಸೆಕೆಂಡ್ ಗೌರ್ಮೆಂಟ್ ಮ್ಯಾಟರ್ ಸ್ಟೇ ಆರ್ಡರ್ ಬಂದಿರಲಿಲ್ಲ ಬರೀ ಕನೆಕ್ಟೆಡ್ ಮಾತ್ರ ಆರ್ಡರ್ ಆಗುತ್ತೆ ಮೊನ್ನೆ ಚೆಕ್ ಆಗಿ ಸ್ಟೇ ಆರ್ಡರ್ ಕ್ವಶನ್ ಬಂದಿಲ್ಲ
And counsel for the petitioner. The matter spoken to means that outside interim order sought for was not passed 29/1/2024. Taking note of the said submission and submission regarding interim prayer, there would be an interim order.
Sharing matters, serial number four. Bring it from issue of. Matters.
Now that miscellaneous appeal is still pending. Miscellaneous appeal is still pending.
Aspect. Very tax. Student checks. 4 years, 3 lakhs in all. Right? You will not get anything. Right? You get the corporation fees. That I have got to pay more. You feel like that.
So correct, in the miscellaneous appeal, there was a direction. Till the appeal is disposed of, you have to accept the tax as declared. They are not doing that. Learned Council, Mysore City Corporation. Geeta Devi is directed to accept notice for respondent 1 and 2. List the matter in the preliminary hearing list, short date. 14. We appreciate that despite your enrollment being in 1960, you are so actively participating.
Remain in your house as far as possible. Walking is the best medicine.
Yes.
In my mind also. To fight, I think that's it.
Same order. We'll have it on the, we are putting all, bunching it and having next week. We want to pass the directions for others who are not before court also. This Land Council A.V. Gangadharappa is directed to accept notice for the respondent number 2. AGF first respondent lists the matter on 15th along with,
5.2.
yes.
The fence is Mahesh.
All the right, demand voted all on the day. In one single day, sir. So, not on the-
Same orders. At Annexure B, page 20, there appears to be discrepancy in the area. Same order. We have passed orders.
Third order. And issuing notice for attachment of removal. So that also will be accepted. All that.
Inspection, date of inspection, 13. 15. In the second. In the interregnum, in the BBMP not to take precipitated steps pursuant to
C to H and C1 to H1.
C to H and
C to H.
C1 to
H1.
H1. Full stop. Until the next date of hearing. It is further made clear that in light of the order of restraint, question of attaching the immovable property or proceeding to seal it would not arise.
Here, is also.
That will say. That will say.
Another of the thing.
Number 7, Ramesh Kumar. Number 7, Ramesh Kumar.
Pass over. Real estate. Now, in this matter, you examine the 248.3 order has been set aside in the appeal. Now, the complainant is filing a writ. Is it maintainable? Examine. No, correct. But now, to examine it, he wants to challenge it. Whether it could be entertained at his instance, because it's essentially one between you and them. So at the preliminary stage itself, we can dispose it of. If finally there is any lacuna in the notice and it's going to be redone, then he can't interfere. There's no question of it. Even otherwise, suppose a appellate authority has recorded satisfaction, there ends the matter. He has to go to the civil court. We can't sit and enter into his contention, stating that the appeal finding is wrong because he is not a party. So examine it at preliminary hearing only requires to be disposed. Make a note of it. Relist the matter on. Yes.
Number 8, Professor what else?
Now the 248.3 order is not passed. Now, correct. your contention that there was no notice to you, etc. We'll ask them to examine it before 248(3) order is passed.
Itself, directed to demolish the.
No, that will clarify. We'll clarify that. That cannot be done till the final order is passed. You give him a copy. Give him a copy. Now, it's only 248(1) and 2. Main contention is there was no notice to them.
The same day notice of which, because only the 9 months, order also on the same day, on 9 month notice.
248(3) order is not yet passed. Whatever contention you have raised, including the grounds herein, must be taken note of. And he's apprehending that BBMP is very efficient sometimes. So he doesn't want demolition before 248(3) order is passed. That's all we'll clarify. Yes, yes. Petition. He filed. Seeking for issuance of writ of pressure RI. Last the notice dated 9/1/2024. Issued by respondent number 2 as annexure H. It is an order under 248(1). No challenge. Has also sought for issue. The mandam is to direct respondent number 2 to consider the representation at annexure H1. Where is H1? Representation at annexure H2. Right. Petitioner submits no sufficient opportunity was granted for furnishing of documents as per the previous notice. Spot inspection can be done during his presence. Notice that the respondent BBMP passed a provisional order at annexure H under 248(1). Out to the patient. It's a further notice that in terms of section 248(2), and it's granted to show cause as to why the provisional order is not to be made absolute in terms of section 248(3). Notice issued on 9/1/2024. Petitioner subsequently, petitioner has made a representation at annexure H2 dated 19/1/2024 as referred to above. He submitted that till date, no order under 248(3) has been passed. So, needless to state that the representation at annexure H2 is to be considered by the respondent BPMP, and petitioner is at liberty to make out a fresh reply that to be taken note of while passing order under 248(3). It is to state, till passing of order under 248(3), question of implementation of 248(1). Not arise. All contentions are kept open. All contentions are kept open. Petitioner to make out additional reply as referred to above within a period of 10 days, 2 weeks from date of receipt of certified copy of the order. From today. That is, how much time they can correct it? If you look at the provisional order, that sentence is written for at least some floors.
Number 9, Mr. Joshi.
Now, whether you have filed an appeal, you file it, we'll protect you till then. So where is that order of 248(3)?
You are not passed the order. A condition order, there is no order passed. Delhi orders were not, these are provisional orders, all no possible.
Then you find out, you give him a copy. Mr. H, page 36. 356 order. We'll have it tomorrow, day after tomorrow. If you get the copy, we'll have it, so you can serve it across. When do you want? Friday. Monday. Release the matter. Tuesday. Release the matter on. So in the preliminary hearing stage. In the interregnum, no precipitated steps to be taken insofar as Mr. H. Till the next date. You have a plan or no plan?
I have a plan.
You try to fix that notice for time 1. Something Pawan Kumar for.
Number 10, number N.
I want you to argue. I tell you. I think I will not cause, if I'm going to cause damage, I'll definitely adjourn the matter.
So, the petitioner had rented the property and without any.
You've given a copy. Have you given a copy? Yes. Petitioner.
The petitioner, he runs a business. He runs
No, the petitioner is the tenant, isn't it?
yeah, the petitioner,
So the landlord has
the land,
not paid the tax.
the landlord is not paying tax. And without any notice. So that is something.
So what is the, go to the show cause notice letters. Is it non-payment of tax or revising of tax? Go to the show cause notice letters. What is the, how much is the demand now? Page 46. Page 46.
That is the
Now here, 9,671 with a penalty and interest. Now, how much is the rent that you are paying? What is the rent that you are paying?
advance of 11 lakhs 9,000.
What is the monthly rent? Yep.
1 lakh.
Now, how many tenants are there?
There are 4 rooms and 3 offices.
None of the tenants have filed a rent.
I'm unaware.
Then you get instructions, we'll have it tomorrow. One, you'll have to go on paying the rent to the BBMP, which they'll offset towards the tax. If you want a dealing order, you make some payment which will be adjusted to demonstrate your bona fides. Now there are how many tenants you calculate proportionately. You make your own calculation. How many tenants are there? With respect to the extent in yours, proportionately regarding the tax amount. Tax amount of 8,29,671. You make a offer, how much you're going to pay is cleared. And you get instruction and make the statement tomorrow. This is the matter. Let them pay proportionately like how we did in that other matter. If all the tenants pay proportionately, we'll order for de-sealing of those. And the monthly rent you pay to them. That would be adjusted to lawfully claimable tax. Where Council Pawan Kumar accepts notice. Be responding. You can ask if the other tenants are going to come, you find out. We can pass a comprehensive order. AGA accepts notice for the first respondent. Pawan Kumar for 2 to 4. List the matter in the preliminary hearing list tomorrow.
Number 11, one week.
You need the show cause notice. Give him a copy. Give him a copy. Now you give him a copy. Now the orders are passed. There's no show cause notice. Then you take a short date, produce the show cause notice. Let us see. Now the 2,13,000 is the disputed. When will you get the show cause notice? When do you want? Relist the matter in preliminary hearing list on Monday. Then Council Pawan Kumar accepts notice for respondent 1 and 2. The respondent BBMP is not to take precipitative action pursuant to annexure A to E till the next date. But you have to find out if there's a mistake in your declaration and you have declared less, then you will have to make some.
Not in case.
Yes. Give him a copy. Page 37. So we pass the same one. We'll fix a date. So we fix a date at the site. In their presence, let them make out their measurement of self and tenanted. You produce documents to show when it was tenanted, usage, in which category falls, etc. Then let the report come. Then we see finally what to do. Tenants at this to be present. Found the petitioner at the site on 13. List on 21st. We may not take precipitated steps pursuant to Pursuant to nature F1 to F5 and G to G4. Then see.
Number 13.
Page 9. Just wait, just wait. Just wait. Nim copy ಕೊಡಿ ಒಂದು. Page 9. Just wait. Huh? Huh. So let us see. We'll fix a date. Let a report come. But one thing you must clarify upon instruction. We will direct for an inspection and preparing up of a report. There you can go and tell them when it was let out, what is the measurement. Measurement, they'll do it in your presence. But just once that report comes, you must obviously undertake that whatever the measurement that comes out in the report, you will have to reassess the whole thing and make some deposit.
Separate, not consistency matter. Conditions should come there on the side. But on the other hand, the appeal is given under section 147, 146. The only one of the chief, the commissioner, who has passed the audit under section 144, 16.
No, come, we'll let.
Even the same person who has passed an order, after challenge before the same.
No, that we'll see. Let they first give a report. Same order, but there's a huge difference. On the spot inspection, you make it clear, you be present. If it comes out that there's a difference, then you must undertake to make a deposit, and then we'll see what is to be done. The same order to be present on 13th, 7:30 AM. Not to take any precipitative action pursuant to annexure E to H, E to J. The next day, list the matter on
14. Adana Shakti.
give him a copy. Yeah, 313 note. Just one. What is? What you say? He has no power.
The total officer is the revenue officer who can actually get, because still the speech, man. The algorithm of the title and all, right?
But why are you being so technical?
No, I have. The other president who wanted the sanitary patch in my, like, therefore I. What can give order for document?
313 of
Still see of Bangalore, the PGM.
the new act.
Yeah. To attend and give evidence.
This power is delegated to 74 70. That's the writ appeal state. This matter now has been said. Single judge has said no jurisdiction that has been stayed by the division bench.
About myself. Even he cannot. Because he is not the officer. How can you enter?
No, that is before the division bench. Single judge's order is stayed. Single judge said no jurisdiction that has been stayed now by the division bench. So now,
My city. Just come here, my director, because.
no, you make out a reply now. At this stage, let us see. Let us see. We'll consider it.
Can you see annexure? 36, yeah, I have picture for annexure.
They'll consider it. What is
Subsequent second notice that they have done. Therefore, I'm informed.
age?
Age was 35 lakh. The first notice.
Annexure G is the notice.
Annexure A is the second notice.
Read.
This year. ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಗಂಗೆ ವಾರ್ಡ್ ಇಂಡಿಯನ್ ಸುತ್ತಿನ ಸಂಖ್ಯೆ 5-6 ಎರಡನೇ ಕರ್ನಾಟಕ ಬಡವರ ಬೆಂಗಳೂರು ಇಲ್ಲಿ ತಾವು ಸಾರ್ವಜನಿಕ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ಮಳೆ ನೀರು ಹೊಳಿತಲ್ಲಿ ಸಂಪರ್ಕವನ್ನು ಮುಚ್ಚಿ ಕಾಂಪೌಂಡ್ ಗೋಡೆ ನಿರ್ಮಿಸಿದ್ದೀರಿ ಎಂದು ದೂರು ಬಂದಿದ್ದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ತಮಗೆ ಈ ಕಚೇರಿ ಉಲ್ಲೇಖಿತ ಪತ್ರದಂತೆ 16/1/74 ಬಿಬಿಎಂಪಿ ಕಾರ್ಯಕಾಲ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ ಪ್ರಸ್ತಾಪಿಸುವ ಸಂಬಂಧಿತ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲನೆ ಕಚೇರಿಗೆ ನೋಟಿಸ್ ಮುಂದಿನ ಒಳಗಾಗಿ ಸಲ್ಲಿಸಲು ತಿಳಿಸಲಾಗಿತ್ತು. ಅದರಂತೆ ತಾವು ಸದರಿ ನೋಟಿಸ್ ನೀಡಿರುವ ಸಮುದಾಯ ಸಮಾಜವೆಲ್ಲ ಉಲ್ಲೇಖಿತ ಪತ್ರದಂತೆ ನೀಡಿರುವ ನೋಟಿಸ್ ಸರಿಯಾದ ಉತ್ತರವಾಗಿರುವುದಿಲ್ಲ.
Just 1 minute. Now, this will treat it as a notice. Let him make his reply. Question of taking action will come only at the stage after inquiry on the basis of considering his reply. We clarify that and protect.
And now they say they are going to demolish the compound.
That will protect. Now, what is the inquiry now? After this, how is the inquiry?
And 2 days notice I have been given.
Just wait. Correct. Now, for that also, there must be an inquiry that, so if whether it has to be done by the revenue department or the BBMP, there must be an inquiry wherein you give him an opportunity of hearing, sufficient opportunity of hearing, consider all his documents, objections, and then pass a considered on. Council Pawan Kumar. Please for respondent 1 to 4. Petitioner. Notice. At annexure B. At annexure A. Dated 30th January 24. Whereby petitioner has given 3 days time. Make out his reply. Wherein the notice refers to a time of 3 days that was given for making out reply. The same found to be unsatisfactory. And as no further documents have been submitted, in 2 days' time, issuance of notice, documents are required to be submitted. Further, there is failure to do so, compound wall built be removed by the respondent BBMP and cost recovered. Third counsel for the petitioner admits that initially notice came to be issued at annexure G dated on 16/1/2024. In terms of the said notice, it was asserted that the roads were encroached upon and the stormwater drain was closed and compound built up by the petitioner. 3 days time was granted. In response, G, you gave out a
I
reply.
have to.
In response to the said notice, the petitioner submits a reply was made out on 17/1/24. 17/1/24.
I have said that not any compound unauthorized encroaching is correct.
Asserting that there was no encroachment as alleged in the notice. And that there was a civil suit pending.
The landowner has filed the suit in respect of the entire survey number 94.
In
That
OS
is what is done.
in OS 395 of 2013.
It's going to be ARO, and also one we are CWS for making all this. They are there, they have purchased the site subsequently.
It is further submitted that despite such no reply at annexure H, a fresh notice has been made out at annexure A, which is in the nature of an order, giving only 2 days time, which is in violation of principles of natural justice, as no sufficient opportunities afforded. It is noticed that petitioner made out a original reply as far as the notice. So far as the notice, the respondent BBMP has once again called upon the petitioner to furnish documents. Though annexure A provides that action for to state to the notice, even otherwise, upon reply being received to the notice at annexure A, inquiry is to be held following principles of natural justice before passing an order determining that there is encroachment by the petitioner. Such a summary inquiry is to be held in terms of the statutory provisions and power vested by the respondent BBMP. Procedure under section 229 is required to be followed. And it is only thereafter that action can be taken. Next. The petitioner to make out his reply to the notice at annexure A within a period of 10 days.
Because 15 days, may make it.
2 weeks from receipt of certified copy of the order. Thereafter, the respondent authority to afford an opportunity of hearing and follow the procedure as contemplated under 229 and proceed in accordance with law. Needless to state that till such determination is made after inquiry as ordered above, question of taking any precipitative action by the respondent BBMP does not arise. All contentions are kept.
Okay, now, then on that, state like month.
We have mentioned. I passed such up.
Yes. E22, they are inspected and changed the data. And I have paid up to date tax for the period 2021 and 2022.
There is no show cause notice
No, there is no
that you
notice.
get it. So when do you want? Then Commission Pawan Kumar accepts notice for the respondent. Case number 224. AG accepts notice, directed accepts notice for respondent 1. Show cause notice may be required to find out as to whether there has been any discrepancy between the self-assessment return vis-a-vis the stand of respondent BBMP based on the revenue inspector's report. Finally, for the respondent BBMP to secure show cause notice. Here's the matter in the orders list on 12th. In the interregnum, respondent BBMP is not to take creative action pursuant to annexure A. Interim order would be enforced till the next date.
Okay, we for related purposes. I don't care that they make, this is the area that what to-
Where is the show cause notice?
People are actually-
Page 81. Give him a copy.
Not that. Yes. But here cannot be. Giving there. What is the time frame of the game there?
Page 81. Pass the same order. Same order. Be present along with the tenants. On 13th. 13 to 2024. Not respondent BBMP not to take precipitative steps pursuant to annexure. Annexure A to A5. H to H5 till the next day. Here is the matter on yes. Dispensation.
Matter, number 17 again, serial number 18, reject A.
So we dispose it of in terms of the compliance report. You find that compliance. Then now they have filed that compliance report. We'll record that. No. That's it. Not for issuance of writ of certiorari. was the memorandum of understanding. That the respondent is seeking to construct the toilet. On the pavement and on top of and over the storm water drain. It is intended to lease out the same for maintenance to the fourth respondent. He submitted that the petitioner's apartment complex is adjacent to the proposed toilet. During the pendency of the proceedings, the court is filed responding PDMP pursuant to order of this court. Same reads as follows. The said report makes it clear that the respondent BVMP has instructed the fourth respondent to remove the construction made over the stormwater drain immediately. Right of the same question of adjudication list does not arise, while making it clear in terms of annexure R1, respondent BVMP is to ensure the incomplete construction stated to have been made over the stormwater drain is to be removed. Accordingly, petition is disposed. You must be big-hearted enough to give some area for the public toilet. Correct, I'm saying you must be large-hearted to give a part of your area to put up a public toilet. You must put it forth. There must be some social responsibility by us also. Yes.
Number 19, on the top sheet.
Compensation can be paid to the yes, whose land has been acquired by corporation. A year was not made in the we filed an amendment application. Action should consider our presentation.
So that is late for 2 days time also. Objections have been sent. Affidavit from the corporation is yet to be received. 2 days time is granted, we will file our objection.
Now they have utilized that for road. How much land they've utilized? 1 cent.
0.5 cents. $0.37.
They have utilized. That they have admitted.
They have what they have done is we will give you PDR and they did not issue PDR.
No, but where is the just point out the regarding the utilization where there's some reference that they were doing.
They have kindly see page 28 annexure C. They have prevailed upon the petitioners and they have Parijana Patra ಅಂತ ಹೇಳ್ಬಿಟ್ಟು relinquishment deed ಅಂತ ಬರೆದುಕೊಂಡು in page number 32 the sketch sheet is produced. The entire sketch area, my area it is. It is in the heart of Mangalore town. And they assured me that they will give me TDR for the land that has been acquired. Now I have been telling them that I don't want TDR, you give me money. That they have to consider proper need because they have to find out. Because it is a land purchased by my father in the Rochester in page 17, annexure A.
Though there is a relinquishment deed. However, now since the consideration for that was TDR, which they don't want, then you have to,
As per the objections and the instruction from the corporation, there was a letter dated 17/10/23 sent to the petitioner, wherein they were asked to relinquish, execute a relinquishment deed. But subsequently, they have not accepted that letter. The relinquishment deed is not executed by them. Is what the
you file it,
instruction we have received.
file it.
Yes, Lord.
The IA,
Annexure C in
let them file, we'll dispose it.
Yes.
The petitioners have filed petition under Article 226, read with Order 6/17, seeking to amend the petition. Taking note of the nature of amendment sought for. The application is allowed necessary amended petition to be filed. Is the matter in the same stage on? No. 14.
Notice.
So you have to file wakalat.
That's notice.
You appear for
Protection.
respondent 1. Mangalore Urban Development Authority, who appears?
We appear from Buddha, but we have not been directed or we have not followed instructions.
Now you take, you are on the panel. Land Council, Hari Bandari is right to take up notice for the third respondent, AGF for second respondent. Smart City Limited, Mangalore City Corporation. AGF for 2 and 5. Emergent notice to 4. Petitioners permitted to serve notice to 4 by hand summons. Relist the matter on 14.
Number 20. One BK.
Yes,
For petitioner, my lord. My lord, in this case, I sought for the dispensation of annexure G, my lord. I had not been provided with the original copy, my lord. They have sent me the photocopies, my lord.
Yeah, yeah. 1 of 24 is allowed. And petitioner is dispensed with production of certified copy of annexure G on the undertaking that the same would be produced in due course.
Yes, my lord. My lord, in the meantime, they are taking precipitate action to dispose me and the people like me, my lord, from that. My lord, in fact, what has happened is it is around 11.28 acres, my lord. And there are 350 families, my lord, since 40 years. They are all coolie workers, my lord. In the year 1994, the government comes and they issue Hakku Patra for around 200 families, my lord. And they assure to issue Hakku Patra for another 150 families, my lord. I furnished a copy of the Hakku Patra, my lord, for your honor's reference, just how it was issued, my lord. Your lordship would find at page 21, annexure C. Thereafter, I have been keeping on requesting them to issue Hakku Patra, but instead now they are threatening me to dispose us from the property because we have not voted for a particular party, my lord, in the election. Now, since mid of 23, they have precipitated the actions, my lord. We are all coolie workers and there are more than 150 families which are yet to be issued Hakku Patra, my lord. So at this stage, I would request your lordship that let them not dispose me till my application under 94C is pending before the authority, my lord.
Under
94 we have made an application, my lord, to regularize our position, my lord,
Where is that?
because we are, my lords,
Where is that? Annexure?
that annexure could not be because they are coolie workers. They did not keep the copy, my lord. But I have furnished the receipts. I have furnished, my lord, for having paid the amount and made the applications, my lord. All the receipts, Swikriti Patra, and also the list of the persons who have made the application. That list is also furnished, my lord. Your lordship would find that in annexure D and E, my lords. They are the list of the persons who are residing and who have made the requisite fee, my lord, for allotment of land.
94C of Kerala Act.
Karnataka land, yes, my lords.
Now, who is threatening to demolish and dispossess?
Now, in fact, the revenue department has instructed the Tahsildar as well as the AC, my lord, to demolish those sites to whom Hakku Patra has not been issued. Your lordship would find the photographs, my lord, which I have furnished there. It contains cluster of houses, my lord. In this, out of some 350 people, 200 Hakku Patras have been issued. Intermittently, there are certain portions where Hakku Patra is yet to be issued, my lord. And all comes under the same similar survey number, in one single survey number only. Just because certain persons feel that we did not vote for a particular political party, now they have expedited the matter to see that at least these 150 persons who have not been issued Hakku Patra be removed, my lord.
Yeah, but is there any
My
list?
lord, my lords.
Is there any list of beneficiaries?
Yes, my lord. There are 200. I have just furnished one Hakku Patra, my lord, to whom it was issued. There are 200 like this, my lord. I just furnished at page 20, my lord, just for your honest reference, how this Hakku Patra was issued.
What we are asking is there list of beneficiaries that was prepared.
No, my lord, I have not furnished that, my lord. I have not furnished, my lord. I have furnished the list to whom yet to be Hakku Patra is issued. Your lordship would find at page 20, running page 21C, my lord. There the certain sites is there in that sketch. That particular allotment letter have been issued to those sites, my lord. Your lordship would find around 200 sites, my lord, bearing different number. In between, there are patches, my lord, where there is no site. This thing has been mentioned. I reside in those places, my lord. If your lordship would find, see page 21, my lord. In that, there is sketch where different site numbers have been shown. To them, Hakku Patra has been allotted, my lord. In between, there are pocket of boxes where I am in occupation, to which Hakku Patra is still pending. So that is why no site numbers are shown there.
The petitioners submit that they put up construction. So, Hakku Patras have not been issued. Submitted that insofar as those who do not possess Hakku Patras, the respondent authorities intend to demolish the construction to cover vacant possession. Further submitted that applications have been filed under Section 94C of the Karnataka Land Revenue Act seeking regularization. Subject to further consideration, the respondents to maintain status quo as regards to property as on date. PG is directed to accept notice corresponding 1 to 4. Executive Officer, Taluk Panchayat, Srirangpatna. General Counsel MS Devraj is directed to accept notice for the 5th respondent. 5th and 6th. 5th and 6th respondent. This is the matter after 2 weeks. Anyhow, you find out if there's any list of beneficiaries, one. And even otherwise, you have to evict them according to due process of law. Let us.
Highly obliged, my lords.
Number 21.
Whatever you file now, you give us a solution.
They're not intended for me.
Let us see
More
what-
than.
Have you served copy?
Yes.
What is the stand? You want to have a look? You have a look. You file a rejoinder.
In 51 days, the board will come.
Let us see. You file a rejoinder. Let us see.
They also surveyed, they have given the measurement to the authority. The stating that the land was giving compensation, this application was filed. Petition objections to the petition was filed by them.
Let us,
Land was not acquired. Even then, no notifications were not, they were acquired. Even today, not 2016, they were acquired. Today, one phase, they were given the. He is aged about 70 years, but still he is in period of post age. Everything under 16, he is giving applications and applications to the authorities. Even commissioner they have gone to the spot on their survey and they have written the connection. Everything is the record which is set.
you find a rejoinder everything.
Expectation they accept because they say they take compensation in 3 months. Then thereafter, they said, Nashika suggested to file the academic commissioner itself. Then this application is being filed by the
Statement of objections are filed for rejoinder of the petitioner. Sign is granted. List the matter, relist the matter on 16. Let us see. Let us see. Let us see. Now you have put it in writing. We'll consider.
Number 23, the MB.
Either necessary amendment. You consider the to take notice because of direction from the court. Direction from the court means something.
You have carried out the amendment. Petition. Have you filed an amended petition or carried out? Now state you will have to accept notice for the second respondent. The AG accepts notice for the second respondent. Copies to be served. Advocate forthwith. System. You're filing? Alliance Council MS Devraj files Wakalat for respondent number 1. Release the matter week after next. After 2 weeks. Yes.
Number 24, student number 25, Nuram K.
They're seeking for not to make use of this road for road widening.
This may not, it is not included that the land belongs to the petitioner. But the petitioner may not, according to the ADLR report, and encroach 2 feet of public road melons. And I produce melons. Along with the name, I produce all the documents. I page number 10 melons.
Page number
10 melons. I have produced documents.
Yes, read. Yeah.
ಮಾನ್ಯ ಗುಂಡಾಟಗಳು ಸಹ ನಿರ್ದೇಶಿಸಿರುವ ಆನೆಕಟ್ಟಾಲು ಬಂಧನ ಸೌಕರ್ಯ ನಾಲ್ಕನೇ ಸೋಲು ಚಂದಾಪುರ ಗ್ರಾಮದ ಅಧಿಸಭೆಯನ್ನು ಮತ್ತು ಹಾಗೂ 200 ಗ್ರಾಮ ಸಭೆಯನ್ನು ಪರಿಸರ 2/2 ಮತ್ತು 13/3 ದಾಖಲೆ ಪ್ರಕಾರ ಆಯ್ಕೆಗೊಂಡಿರುವುದು ಚಂದಾಪುರ ಪುರಸಭೆ ಅಧಿಕಾರಿಗಳು ಹಾಗೂ ಬಡಾವಣೆ ನಿವಾಸಿಗಳು ಅಳತೆ ಕೆಲಸವನ್ನು ಪೂರೈಸಿ ಗಡಿ ಗುರುತಿಸಿ ನಡೆಸಲಾಗಿದೆ. ನಕ್ಷೆಯಲ್ಲಿ ಈ ಬಣ್ಣ ಅಂತಾರೆ, ಯಾವ ಬಣ್ಣ ಅಂತ ನಾವು Grade 9 ಬಂದ್ಬಿಟ್ಟು grade 9, grade 8 ಅವ್ರು ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಆಗ್ತಾರೆ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಇಲ್ಲಿ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ನನ್ನ ಕರೆಯಲ್ಲಿ grade 8 ಆಗ್ತಾರೆ. ಮುಂದುವರೆದ ಉಲ್ಲೇಖ ವಿಚಾರ ಭೂಮಾಪಕರು ಸರ್ವೆ ಗುಂಪಿನ ಕಣ್ಣುಗಳನ್ನು ಹಾಕಲಾಗುತ್ತದೆ. ಅಭಿವೃದ್ಧಿಕಾರ ಪ್ರಾಂತ್ಯಗಳ ಸರ್ವೆ ನಂಬರ್ 90/9 ಮಾಡಿಕೊಂಡು ಆಕ್ಷೇಪಣೆ ವ್ಯಕ್ತಪಡಿಸಿ ಭೂಮಾಪಕರ ನಿಯಮಾನುಸಾರ ಸರ್ವೆ ಮಾಡಿರೋದ್ರಿಂದ ಸರ್ವೆ 13/9 ಮಾತನಾಡ ಮಾಡುವಾಗ 6/9 ನಮಗೆ ತಿಳುವಳಿಕೆ ಪತ್ರ ನೀಡದೆ ಏಕಪಕ್ಷೀಯವಾಗಿ ಭೂ ಸರ್ವೆ ಮಾಡಿರ್ತಾರೆ. ಪ್ರಸ್ತುತ ಹಾಕಿರುವ ಅಳತೆ ತಂತ್ರವನ್ನು ಸರಿಯಾಗಿಲ್ಲವೆಂದು ವಾದ ಮಂಡಿಸಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ವಿವಾದ ಉಂಟಾಗಿದ್ದು ಸರ್ವೆ ಬಗ್ಗೆ ಆಕ್ಷೇಪಣೆ ಮತ್ತು ಗೊಂದಲ ಉಂಟಾಗಿರುತ್ತದೆ. ಅದರಿಂದ ಸರ್ವೆ ನಂಬರ್ 13/3 ಮತ್ತು 90/2 ಅಳತೆ ಮಾಡಿ ಜಮೀನುಗಳ ಹಕ್ಕುವಸ್ತು ಹಾಗೂ ವ್ಯಕ್ತಿಗೆ ನಿಲ್ಲಿಸಿರುವ ಸುತ್ತನ್ನು ಗುರುತಿಸಲು ಜಂಟಿ ಸರ್ವೆ ಕಾರ್ಯ ಕೈಗೊಳ್ಳಲು ಕೋರಿದೆ. ನಿಯಮ ಈ ವಿಷಯದ ಬಗ್ಗೆ ವಿವಾದವಿರುವುದರಿಂದ ಹಾಗೂ ಸರ್ಕಾರದ ಯೋಜನೆಗಳ ಕ್ರಮಗಳನ್ನು ತ್ವರಿತವಾಗಿ ಅನುಸರಿಸಬೇಕಾಗಿದ್ದ ಉಭಯ ಜಮೀನುಗಳನ್ನು ಜರೂರಾಗಿ ಜಂಟಿ ಸರ್ವೆ ಮಾಡಿ ಇಲ್ಲಿ 2024 ಬಿಡ್ತಾರೆ ಸರ್ವೆ ಮಾಡ್ಬೇಕಂತ. ಇಲ್ಲಿ ಡಿಸೆಂಬರ್ 2022 ಅಲ್ಲಿ ಬಂದು ವಿತೌಟ್ ವಿಷಯಕ್ಕೆ ನೋಟಿಸ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಪೀಸ್ ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲಿ ಸರ್ವೆ ಮಾಡಿಲ್ಲ. ಸರ್ವೆ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ನೀವು ಈ ಲೆಟರ್ ಸರ್ವೆ ಮಾಡಿ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಇದ್ರೆ ನೋಡ್ಬೇಕಂತ. ಈ ರಿಪೋರ್ಟ್ ಏನ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ, ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಲ್ಲ.
Just one. Now, government, pursuant to the order of 2124, that's why he's pointing out that the letter of 2124, there's a reference by the town municipal council that there has to be an inquiry, survey. So in terms of that, then you have to conduct a fresh survey in his presence. Just read that once again. Just wait. Page 8, last paragraph. Once again you read it. ಮುಂದುವರೆದು
Before that survey was completed, and December 22nd, they will come and remove the.
Let us.
Standing is.
Okay.
No,
that will put them on terms. So far as whatever loss is caused to you by, resorting to survey without notice to you. Now that will keep it pending. Meanwhile, in terms of what they've stated of having a joint survey, let them do it with notice to you. We'll keep it pending. We'll see then what order to give. That you have to tell us. I'll have it tomorrow. I'll have it tomorrow. You find out and you tell us which date, and then we'll pass an order. Yes. Now you are the owner of 90/1. The counsel for the petitioner draws attention to the memo filed counsel for by third respondent. Documents filed along with it, including ADLR report dated. Where do you get that date? ADLR report. Conducted ADLR report that is conducted prior to filing of the writ petition. Pointed out that in terms of the letter dated 2/1/2024 addressed by the Town Municipal Council Chandapura to the Tahsildar and Assistant Director of Land Records. The Chief Officer has suggested for having of a joint survey in light of the dispute raised by the petitioner regarding the earlier survey report, which according to him was conducted without notice to him. Taking note of the letter of 2/1/2024 addressed by the Executive Officer, Town Municipal Council, Chandapura, to the Tahsildar, the joint survey as envisaged in the said communication dated 2/1/2024 to be carried out with the notice to the petitioner. The petitioner to be present at the site on 21st of February at 11:30 a.m. Full stop. All other procedural formalities required as regards notice to other affected parties is to be complied with by the survey authorities. Survey to be conducted under the supervision of the Assistant Director of Land Records, jurisdiction Assistant Director of Land Records. Consequent to such survey, report to be filed before this court within 10 days thereafter. Deal is the matter in the first week of March. Interim order earlier granted is extended till the next week.
Number 26. And the L.
Yes. Statement of objections filed on a BBMP, same is taken on record. We'll list the matter week after next. This is against 253. So you get the records. The records, at the time of hearing, you keep it.
The presence of the petition, part inspection. First notice was issued stating that the inspection began 16, and 16 to is adjourned. Again, the second notice said 16 to has been conducted. That we have placed it on the record of this. And ultimately, nothing has been done. Last time, no precipitated action.
The matter week after next, dateful. The earlier direction not to take precipitative action is extended till the next date. Respondents counsel to keep the appeal papers present for perusal by the court at the time when the matter is taken up for hearing. Let us see. The respondent, BBMP, not to take any precipitative action in the next state.
Number 27.
Extension of 5 years to even some reception of date in the percentage.
Take me to the relevant paragraph. No, you're reading at paragraph. Karnataka Janana Marana. Now, yours is a certificate that was registered before 1/1/2000 or after 1/1/2000? What is the date of your certificate? Huh. No, just 1 minute. The last 3 lines. ನಿಯಮ ದಿನಾಂಕ 1/1/2000 ನಂತರ ನೋಂದಣಿಯಾಗಿರುವ ಜನನ ಘಟನೆಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ 15 ವರ್ಷದೊಳಗೆ ಮಗುವಿನ ಹೆಸರು ನೋಂದಾಯಿಸಲು ಅವಕಾಶ ಕಲ್ಪಿಸಲಾಗಿದೆ. So 15 years if it's registered after 2000. So 15 years. So now yours is registered on 2006. So 2006 plus 15. 21. Huh? But only for those before 1/1/2000, another 5 years is extended. That's what the first 4 lines state. That is with respect to 1/1/2000. Then how do you get now? Yours is then you have sought for inclusion of the name on 2020. Then it comes little outside. Let us go to page 3. Let us see what is the. No, you find out whether in terms of para 2, they have taken any steps to extend this. But if you look at 7322, it's only for old ones they've extended. You find out. The petitioner filed a memo and produced the letters 9/10/2019 and 7/3/22. It was taken on record. The stand of Honorable BBMP relists the matter. Yes.
15.
number 28. More.
Plan is not, they have not yet you consider it. See, petitioner has sought for, it's a bit of in the nature of mandamus, to direct the respondent PBMP to consider and pass orders on the application seeking sanction for construction of residential building stated to have been made on 26/11/2022. Petitioner also states that after making of application seeking sanction plan, presentation was made by the petitioner that order to be passed on the application expeditiously. He submitted that despite application being made on 26/11/22 and after taking note that the petitioner is also paid betterment charges. And despite the representation at Annexure D, no orders are passed. The counsel for the respondent BVMP submits that they would consider, they pass orders, consider pass orders regarding the application of building permission at Annexure B in accordance with law within a period of 4 weeks. 4 weeks from date of receipt of certified copy of the order. Full stop. During such consideration, is the petitioner is called upon to clarify or file documents, additional documents as may be required. Petitioner to cooperate with such requests. Accordingly, petition is disposed of. Let us see, let them give one, whatever clarification they want, let them put it forth. You reply. Now you take the show cause notice, then we'll see, we'll pass the same order. Counsel for the respondent BPMC submits that the show cause notice required to be looked into just to note the basis on which the self-assessment return was sought to be reopened by the respondent BBMP. Accordingly, relist the matter on 12th. In the interregnum, no precipitative action to be taken pursuant to annexure H2M till the next date. Correspondent 192.
Set aside. Relying on the statement of the verified by the
Now the Kata as on date stands in whose name? As on date.
By virtue of this order, the second respondent cancellation.
Light of the contentions raised and taking note of the submission and the name of the petitioner. Date. Pursuant to the impugned order, same may be cancelled. There will be an order of status quo to be maintained regarding the Kata as on date. Notice to the AG accepts notice for respondent 1. Executive Officer, Taluk Panchayat. Kolar. Somyaji accept notice for respondent 2 to 4. Emergent notice to respondent number 5.
Number 31, vote of chair.
No, so no, what I'm saying, if now you guide them and you make one, and how do we do from that stage? I'll make that an order of report so that can be followed in all matters. When do you want? It is the matter on. Because once we do that, then we'll follow the same thing to all. Before 23rd, you finish. Correct, sir. That's why you guide them also. Guide them, stating that SOP cannot be contrary. So, by reconciling, if you file, and that is in accordance with the statutory scheme, I'll make note of it. So, for everything henceforth, follow that. But let it be done before 23rd. Otherwise, it will go. 19. Otherwise, we can pass an order. It depends on what. If you can resolve it, okay, let us see. Other matters, one of the matters will do it. Other matters will pass. Otherwise, we can pass a judicial order after noting this time. 15. Let us 15. What is the relief they sought? Correct. So, what is now your objection? So this is covered, is it? Huh? Huh. Connection?
Side.
Whatever it is, by next week, on that day, I'll dispose it. I'm not going to wait beyond that. Relist the matter in the same stage on next week date.
Yes.
You fix a date, let them appear before you. Let them appear before you and explain and make out their clarification. There is the show cause notice from the original file produced by the respondent BBMP dated 22/11/2022. It is noticed that the discrepancy, the divergence between the self-assessment return and the and of the respondent BBMP on the basis of the revenue inspector is only as regards to the usage. Accordingly, in light of the contention by counsel for the petitioner that no show cause notice was issued, the petitioner to be present before the Assistant Revenue Officer on 13th at 3 p.m. along with the tenants. The aspect regarding usage is to be clarified and petitioner to place relevant records to the respondent BPMP who would elicit necessary information and prepare report be submitted before this court. Relist the matter on 21st. The interim order, the direction earlier made, extending respondent not to take precipitative action pursuant to the impugned orders is extended to the next day. You file a copy of this. Show cause. Yes. Appeal was also rejected. No notice is served. What are the stated in the order, the appeal order, as they refer to your contention? Notices are served same day. Where do you get that? Have you produced a copy? Where is the, let us see, where is the, you are saying the 248, 1 and 2 were served on the same day. No time was granted. Produce the records. Should be of the order. Okay. E, annexure E and F. To further consideration. As point BBMP to secure necessary records relating to the appeal proceeding. Counsel Pawan Kumar. Respondents, 1, 2, 3.
Number 35. Here.
You have served copies on all the other counts. Serve on Yogesh Naik, they've served copies to you. Pass over or tomorrow? Afternoon may not be possible. Have it tomorrow. It is the matter tomorrow. Meanwhile, you serve on whoever else.
Matters. Number 36. So,
Decision taken. The whole decision is taken. First, it may dispose of the max system. Directly to that, the request of the petition. Taking note of the decision taken in respect to the other single petition. Within a time bound.
Release the matter on 22nd.
Regular sanction.
Second, it has been big because their lands have been deleted.
No, the order of 31-124. 31-124 order. Order, look at the order of 31-124. Have a look at it. We'll have it next week. Okay, as for BDA. So have a look at the order. The past a detailed order. Relist the matter on short date for the next week.
14.
Have a look at the order. Yes.
Vishnu Kumar.
Yes, I'm appearing for respondent number 1 to 3, my lords.
Yes.
Lords, on last occasions, I have made the submissions that there are petitioners owing 3 properties, wherein
Yes.
they cleared of the 2 properties, wherein they have to clear for 8 point.
Let him, they have to respond. No representation on behalf of the petitioner. The matter is up to me. At request made on behalf of the respondent, list the matter after 10 days. Next.
Number 40.
Now he's taking revenge. In the previous matter, you took time.
Number 40. Vivek.
Because one is a report indicating the sketch and the extent of the land as well as where the lights have been taken. Which right? We have not received a copy of that report yet.
Who has to file? Respondent number? You appear for?
That the respondent has laid pipes across the property, wherein the which is contrary to the Act. The Act in section 77 stipulates that the minimal damage ought to be.
Okay, but let them file the report. A report to be filed by R2 in terms of the order dated 18/12/23. Deal is the matter week after next. Yes, sir.
One, today,
Request. No, correct. Yes, yes. Revived. No, now it's revived.
No, I filed an application.
Ah.
Not a count. That's what the officer told me. There must be 1 week time. Last week, I give the letter also.
No, correct. Now that was 328. Appeal you filed and withdrew it.
Withdrew it. That's
Correct.
why to recall that order, I filed an application. It's given to the lawyer. The lawyer said it does not come before the court.
No, just 1 minute. Now this OS 328 only is an injunction in accordance with law. That's all it would be, isn't it?
But restraint, take hearing for the matter.
No, but at least you get a clarification. I'll record that. Now the order.
Pass an order, so
Correct.
that I think produce that.
Yes.
Let me say, for carrying out the statute duty, not an injection.
Because there are ample clause in the section 187 and
It's there, but the injection is operated.
The one that issued a notice to the restaurant number 4 for the construction. Day-to-day basis, construction is being proceeded. Even though a notice has been issued to the restaurant number 4, restaurant number 2 municipality.
Eight.
different terms of the definition of commercial. But to other, 2 point.
No, that we'll see. That we'll see. Learned counsel for the petitioner points out that against the order of injunction passed in OS 328 of 2023, Clean's appeal was filed and withdrawn, which has raised serious misgivings on the intention of the respondent authority to ensure compliance with law. The counsel appearing for R2 Sri T.I. Abdullah submits that taking note of the present dispute, necessary steps would be, appropriate steps would be taken as against the order passed in OS 328 of 2023. Here is this matter.
Of the said the miscellaneous appeal member, the restaurant number 2 has issued a notice to the restaurant number 4 to stop the construction work.
Whatever possible in handle, what you have done.
Even though road side is not,
Everything has been done.
it is able to take action on the section 187 or 180 of the act.
The counsel for the petitioner has filed a memo and produced a copy of notice dated 2/1/2024. Whereby direction is passed. Page 3 and 4. Passed, direction has been passed. This one, whereby Respondent number 4, address to respondent number 4. That as a construction is being carried out contrary to the building license. If further construction is to be stopped forthwith. Stop.
So the after given that statement is no deviation from the plan. Based on this letter, they have given the
Let us see. Let us see. Let us see. Then you'll have to plan. No, but then this is later to that.
steps, any statement, there is no deviation.
You don't know.
Now, after finding of this case, they issue this statement that it's deviation. And they have asked for a bit of survey, and we have made a representation first to survey to conduct survey, because there is only one person in us, he has not come for a survey.
Let us see. Let us see. The interregnum. Section of 2/1/2024 is to be enforced by the respondent authority, but it is made clear that the same would not amount, cannot be construed to be an action contrary to the order passed in Vice 328 of 2023. So, the order passed subject to further consideration. Let us say you wait for some time, let it be sorted out. Third counsel for the respondent. Third counsel for the respondent has filed the memo Houston. Copy of the past by withdrawing the MA. Taken on record. Let us see. Their direction, let them enforce it. Yes.
So number 42. Here, number 42. The petition is filed by a housing corporation society. 42. Believe that is what is consider the representation issued by the housing corporation and issued part of the supervisor city secretary and government. 42.1.
42.1.
42.1.
What is the direction to? Let us see. Let us see. That past work matter also, sorry, that matter tomorrow we have adjourned. Just the same line. So the question is whether if you have earmarked it by whichever authority in the layout plan to be a civic amenity, whether it can be made use of by the planning authority. It will be relinquished in favor of
Then the review document is connected. 42.1. Please see the connection A, in the page 61. 42. 42. I address a representation to the exponent number 3, the Panchayat Development Office. To issue the khatas in so far as the residential sites are concerned. So that is the representation.
No, correct. No, insofar as the civic community side, for the civic community side, that sale has been set aside, and that is the subject matter in the 42.1. Insofar as 42, they're seeking other than the civic community side. That you consider it. Now this set.
Residential rights are found. Sale is executed in favor of the allottees. Now, pursuant to sales are also done. So what has initially.
Once, correct, once sale deed is executed, what right you have to withhold the car? Of course, there is a transfer of title. Then you will have to give kata. Whatever conditions you may impose is one. Anyhow, you take a stand by the next date. A counsel for the petitioner submits that the writ petition at scene number 42 is to be considered separately in light of the limited prayer for issuance of kata pursuant to sale deeds. Respondent to take their stand insofar as 42 is concerned by the next date. List these matters week after next. Let us see. No, let us see. We can delink 42. 42.1. No, correct. What he's saying, prima facie, subject to what you say. 42 is relating to kata to residential site. Yes. Date what? Date. Yes. No, but that you just think about that stand. That matter will be coming tomorrow again. Because now suppose in the layout plan, it is says that civic community site is to be relinquished. Suppose they relinquish it. Now can it be dealt with or whether the developer, as they are claiming, no, we have the right to still have control over it. Or once it is relinquished, you can give it out to anybody. That matter just apply or not. Because it has application for other matters. Let us see. Let us see if you can't, I will further accommodate. Yes.
Including the price with quoted by the authorities are concerned. Can you see an agency pay?
NHF?
Agency pay something. Get March 2003. But in again. But there's a non-different indicator. It's a plan which we have to provision of the property. Put a car in the purchase ಮಾಡೋದಕ್ಕಿಂತ ಎಕ್ಸ್ಟ್ರಾ ಟೈಮ್ ಪ್ರೊವಿಷನ್ ಆಗಿದೆ ಹಾಗಾಗಿ 42,428 ರೂಪಾಯಿ ಅಡಿಷನಲ್ ಪ್ರೈಸ್ ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ರು ನನಗೆ ಏನಾಯ್ತು ಅಂದ್ರೆ ನನ್ನ ಪವರ್ ತಾನೇ ನೋಟಿಸ್ ಹೋಯ್ತು ನನಗೆ ತಿಳಿದಿಲ್ಲ ಹಾಗಾಗಿ ಇದು ಕೂಡ ಆಗಿಲ್ಲ ನೆಕ್ಸ್ಟ್ ಪೇ is the e-tender issue in the year 2022 20 years ago this has been issued. Running upon me a sum of 9,56,749.
No, but why did you keep quiet then? For 20 years, 19 years.
I think I have noticed nothing like it.
But you can't keep.
I'm not disclosing that. That's the case and it's a deep pay 21. I'm not questioning that authority. The fresh note is going to be issued. Relying upon me to pay sum of rupees 9,56,700. I am not disputing the price at all. ಇದು ನಾನು ಕೊಟ್ಟೆ ಒಂದು ತಿಂಗಳ ಕಲೆಕ್ಟ್ ಐ ಪೇಡ್ ಮನಿ ಒಂದು ವರ್ಷ ಅವ್ರು ಇಟ್ಕೊಂಡು ವಾಪಸ್ ಕೊಡ್ತಾರೆ ಪೇಟಿಸಿ ಐಡೆಂಟಿ ಪೇ ಮಾಡಿಲ್ಲ was called upon to pay sum of 9,56,745.
Within that 1 month you paid.
Oh, 8 September 2022.
You paid it. Huh.
We have paid 24. Yes. It was not an complaint.
Then what happened?
They kept for a period of 1 year. I mean, I want the investment contract. Now, repeated requested them to execute the same day. I mean, I want the investment contract. It would have borrowed the market and I did you all. Pay see pay another young pay 30.
You read the endorsement?
It is young pay 30.
Yes.
Subject to no one other relation of Bukara, actually happened on the other. ಉದ್ದೇಶ ನಿಮ್ಮ ಮನವಿಯಲ್ಲಿ 18/2 ಅರ್ಜೆನ್ಸಿ ಆರಂಭಿಸಿದೆ. ಈಗಲೇ ಇವರ 23/8/2022 ನಮ್ಮ ಪತ್ರ ದಿನಾಂಕ 12/9/22 ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ನಿಮ್ಮ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಉಲ್ಲೇಖ 2ರ ರಚನೆ ಉತ್ತರದಲ್ಲಿ ವಿನೋದನಗರ 2 ಪುಟದ ನಿವೇಶನ 3ರ ದಕ್ಷಿಣ ಭಾಗದಲ್ಲಿ 3+2.30.2 15.30 40.54 ಹೆಚ್ಚುವರಿ ಅಳತೆ ಇರುವ ಬಗ್ಗೆ ಸ್ಥಳ ಪರಿಶೀಲನೆಯನ್ನು ತಂದು ವಿದ್ಯಮಾನ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಹೆಚ್ಚುವರಿ ಅಳತೆ ವ್ಯತ್ಯಾಸದ ಹಣವನ್ನು ಪಾವತಿಸುವ ಬಗ್ಗೆ 3/2003 ಒಂದು ಅನೆಕ್ಸಿ ನೋಟಿಸ್ ನೀಡಲಾಗಿತ್ತು. ಆದರೆ ನಿವೇಶನದ ಹಣ ಪಾವತಿಸುವ ಬಗ್ಗೆ ನೀವು ಕ್ರಮ ವಹಿಸಿರುವುದಿಲ್ಲ ತಿಳಿದುಕೊಂಡಿತ್ತು. ನಂತರ 18-19 ಸಾಲಿನಲ್ಲಿ ಅಂದರೆ ಶಾಂತಿ ಸಾಲಿನ ಉಪನೋಂದಣಿಗಳ ದರ ಚದುರ್ವಿಷ 1ಕ್ಕೆ 20,000 ರೂಪಾಯಿಯಂತೆ 40.5% ವಿಸ್ತೀರ್ಣಕ್ಕೆ 9,56,745 ಈ ಪತ್ರ ತಲುಪಿದ 1 ತಿಂಗಳೊಳಗೆ ಪಾವತಿಸಲು ಹೆಚ್ಚುವರಿ ಅಳತೆ ಜಾಗವನ್ನು ನೋಂದಾಯಿಸಿಕೊಳ್ಳಲು ನಿಮಗೆ ತಿಳಿಸಲಾಗಿತ್ತು. ಇದ್ರ ಬಗ್ಗೆ ತಕರಾರಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ಅದರಂತೆ ಉಲ್ಲೇಖ 3 ಅರ್ಜಿಯೊಂದಿಗೆ ನಾನು ತಿಳಿಸಿದ್ದೆ 9,56,745ಕ್ಕೆ ಪ್ರಭು ವೈಶ್ಯ ಬ್ಯಾಂಕ್ ಇಡಿ ನಂಬರ್ 8928 ಒದಗಿಸಿಕೊಟ್ಟಿರುತ್ತೀರಿ. ಆದರೆ ಹೆಚ್ಚುವರಿ ಅಳತೆ ಪುನಃ ನಿಯಮಾವಳಿಗೆ ಪರಿಶೀಲಿಸಿದಾಗ 20.54 ನಿವೇಶನವನ್ನು ನಮಗೆ ಮಂಜೂರು ಮಾಡಲು ನಿಯಮದಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ.
No, under what? Now, under what law you are saying that you can't accept that amount and correct. Correct. After that,
after coming to law of same red, we issued the notice, Karnataka wished to pay the different amount. But whether as per the CH-8 Act, which is not permissible for the
correct.
authority to.
Annexure D, what do you say? Annexure D, your own letter, last paragraph. So you gave him 1 month's time, he complied.
The market value of the property is of the at that what has been stated is more than the amount for what has been stated in the market value of the property.
No, but you have stated correct. You have stated
the property cannot be given to the and it has to be put in public auction as per the provisions of Karnataka Corporate Public Procurement Act. Cannot be directly given to the petitioner.
No, just what?
He is in position of the excess land than what he is
No,
entitled to.
now 1 minute. Let us go to the sale deed or the allotment letter. Let us. What is the boundary? Just let us.
Page number 17.
Now, boundary east, west, north, south is mentioned. Now, the excess land Correct. The excess land is found within this boundary. Within this boundary. Then it has been sold. It has been sold. Boundary, boundary.
Actually, when it is in excess of the land, that
No, correct. So what I want to know, whether now no doubt the extent that you had sold was 23.28 square meters, isn't it? That there's no dispute. He also does not dispute. However, within the boundary, according to him, within the boundary of east, west, north, and south, apart from this 23.28, there was some more extra land. Now for that extra land, correct. For that extra land within the boundary, he wants a sale deed. Now, if the land falls outside this boundary, then he doesn't have a case. No. So the only point is whether this extra land falls within the boundary at page 17 or outside it. Suppose it's outside it, we will accept your contention. That no, that you verify whether it's within or outside, and then make a submission. So that you verify. I'll have it next week. If it's within the boundary, then you will not have a difference. If it's outside the boundary, it's a difference. Read is the matter in the same state, short date. 14. Because suppose within the boundary, if it has been conveyed, no doubt he has paid less. Boundary will prevail, and the whole extent is deemed to have. Correct. The excess means next to or within the boundary. If it's within the boundary, then you don't have a case. Yes.
Application measurement excess ಇತ್ತು ಒಂದು ರೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರು ಅದನ್ನ ನನಗೆ ಕೊಡೋಕ್ಕಾಗಿಲ್ಲ ಆಮೇಲೆ ಅವರೇ ಬೇರೆ ರೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರು 80,000 ಇಟ್ಟಿದ್ದು 9.5 ಲಕ್ಷ ಮಾಡಿ 9.5 ಲಕ್ಷ ಐ ಪೇಡ್ ವಿತ್ 1 ಮಂತ್ ಐ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ ದ ರೇಟ್ ಫಿಕ್ಸ್ ಬೈ ದೇರ್ ಅದನ್ನು 1 ವರ್ಷ ಇಟ್ಕೊಂಡು ಆಮೇಲೆ ವಾಪಸ್ ಕೊಡ್ತಾರೆ.
But that's the same order we have passed in that connected manner.
because intimacy is authority. If the compound wall encroaching the excess that is earmarked in the annexure fee, that is clear your rights.
Correct. You have slept over your rights. You have slept over your rights for 20 years. And then you issued an endorsement. He has diligently complied with the endorsement. Let us. You only issued 2022 also. Let us see. Next. Topics of objection is overruled, accepting the submission.
What has happened? The corporation, the respondent, have changed the kata in the name of the respondent 3 to 5. That they are entitled for only 630 square feet. They are the owner. The corporation has changed the kata to 1083 square feet. Excess of 460 feet. For which they are not the owner. Kata is to be changed, pertain to the sale deed they have produced. But for that 630 there is a sale deed. But for 1083 they are no sale deed. Even then they have changed the kata in there.
No, who are you?
I am also residing in this neighborhood. I am a neighbor. My kata also has been changed in there. 1083 ನಲ್ಲಿ ಏನಿದೆ ಸ್ವಾಮಿ ಅದು ನಂದು ಸೇರ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ
Now that order has been given effect to or not yet?
They have changed it. Now they have disposed of this matter, holding that followed by disarmament. I have produced the certificate copy of the repetition. When the matter is, if the suit is pending, it is to be decided there only. But the question in the repetition, there is a serious dispute regarding the title. But in my case, there is no dispute at all. The ownership is not in dispute.
And now you take, will issue notice. That Council Pawan Kumar. Accepts notice for respondent 1 2. Emergent notice to respondent 3 to 5. This is the matter week after next.
The name of the petitioner was shown detail for you. It should be corrected at records.
Yes, sir. The office to correct the name of learned name, learned counsel appearing for the petitioner as Venkateswamy V instead of as shown in the cause.
Petitioner is paying the tax only for the final scratches. In the measurement, the area is much more than 500 square feet. On particular day, when we went for a month doing the measurement, petitioner was admitted to hospital. There is no absence of children that they are connected to. And the area is the building is in a residential area. They are using it for the commercial purpose. They are paying much less than
Have it tomorrow, let him come. No representation on behalf of the petitioner. Relist the matter tomorrow or day after tomorrow? Monday. So see, now once they get interim order, they are not to be seen.
there is a clear deviation, the measurement.
Further, notice that in the order dated 23/1/2024, the typography an error has been in the first paragraph. The first paragraph, full stop. It reads as follows: affidavits have been filed by respondents number 129, full stop. Same is to be read as affidavits have been filed by petitioner numbers 1 to 9. Order dated 23/1/2024 to be read. To the section subject to the modification made today. Full stop. It is noticed that the premises that was sealed was desealed by order of the court dated 23/1/2024. Full stop. However, we find that there is no representation on behalf of the petitioner when the matter is called out. Made clear that if there is no representation on behalf of the petitioner on the next date, necessary orders would be passed. Relist the matter on Monday. Now, we'll redo it like in other matters from 144/13. Taking this to be the inspection in their presence, we will redo the whole procedure. Have it on Monday. So, from 144/13, we'll treat this to be the inspection made in their presence and redo the whole procedure. Request, at request, release the matter Of his objections to be complied with in the interregnum.
7.
You're paid. No, you clarify now. Why are you scared of the tiger? It's not tiger, lion. Or you go there. Let it be sorted out. The petitioner himself as a jurisdictional assistant revenue officer on date 6 months, short date. 9th, relist the matter on 19th. Yes. Yes. Council Sri E.V. Gangadharappa. Such notice for the fourth respondent. 48.1. Read the name of that council. Vijay Somayaji. Yes, what is your stand now?
Playing player and bench player are almost similar. I'd like to play certain facts on record. I request that you be accommodate. Get this one.
Now you're eating into the term. We are on the point. Yes.
Pertains to all the 3,15,000 urban local body councils, TMC, PMC, and TPM, where elections for president and vice president are to be held. There are various notifications were issued earlier in the year 2018 and 19, the challenge was subsequently it was finally elections were conducted. Out of the elections conducted, those were again questioned before until Supreme Court. Pursuant to the existing notifications which were issued earlier, my lord, elections were conducted as is pointed out by the
Now they came into office on. What is the term? What is the term? 13 months. 13 months.
5 years, 13 months, 1 So again, it's a matter of rotation. So, my lord, what has happened is in the XLP, my lord, I have placed on request that in original.
No, but just explain to me. Now it's for 30 months. After that,
On the state and elections will be conducted only for the post of president and vice president. The term of the council is for 5 years. The post of the president and vice president may enjoy the 30 years. Different reservations are issued in accordance with the law and the rotation policy.
so now how much?
First term is over.
When correct? When did it get over?
March 11, 2020. The term ended on 34/2023.
Correct. Now suppose it's not held for whatever reason. Now that will eat into the next.
But the reason why it's watching done is greater, that's the reason and based on record saying,
What has happened before the apex court?
now, as of today,
So request it will be taken up on 23rd or 24th so that we can.
What, correct, now what is there before this apex?
The Armenian reservation. But is the question of the apex where they say that those reservations are not in order and the elections which are held for president and vice president bench is not proper. Is there only the apex vote. But still the elections are conducted at terms of president. But we all think the apex takes it. Then again the entire changes will happen. That is the reason we are requesting date till the 21st matter be listed. Now, some 3 days after that, we will put vote. Because now the honorable apex has also directed us not to do it manually. Now we have developed a software by NIT where everything will be done computerized. There will be no manual intervention. We are going to just feed the reservation data. Because that has been happened by the order. So finally, it may be taken up in the last week, members will pay for the what happens. But it's not only for these PMCs or 3 PMCs, but we have to.
Correct, but why don't you seek, no, no.
We need that to match.
Why don't you seek permission that without prejudice to whatever is being decided, you may be permitted to hold election for the remaining 30 months.
Because the petition is ordered to relied upon the Cabinet Council for the petitioner's member. This is not considered on merit of the Cabinet because it was a very first day the matter was disposed. And we have also preparing the review to bring all these facts to you.
No, correct. What we are saying that we really don't know how long this appeal will take to decide. Why don't you seek permission and move the apex court and place your stand that for the remaining one, give us permission.
Because I will place on record
That is
orders
not
of the court.
it is the petitioner have been fair enough.
But I will place because that is not the reason they have appointed an administrator saying that there is an SLP pending. Just simply invoke 359 appointed to the administrator. Well, they have specifically said the reservation now here. What has happened? 9th term reservation for challenge. Single judge will not cost entire notification. Against which and read to appeal is required. So then in returning the court said since elections are over, let them announce the result. And announce the result and we have been permitted to seek alternative. Against which we have filed an exception. Only 7 TMC local bodies are before, not entire 27. The Supreme Court will not after hearing the matter. In conclusion, this is handling in the manual. There is the chances of every time this is not following the regulations and guidelines. So therefore, they have directed to implement in the future. No? They said that we can't do anything now because bodies are already elected and they are functioning. So therefore, we will prevent for future. So therefore, what they directed NIC to prepare a software, and the software was prepared. And the guidelines was also the state government principal secretary filed an affidavit saying that we have already given them and software was ready and it was reported it is ready. These orders we have placed on those infractions, those SLPs have already become infractions. So therefore, there is no stay for them to say that now there is an SLP pending and therefore we cannot conduct it. It is not on that ground administrator is appointed. My term, my lord, as per Article 243U, my lord, is 5 years. Lordship, kindly see Article 243U. Now the councillor term starts, my lord, from the date of first meeting. There cannot be, my lord, for vice president and president 30 months and 30 months. Once my term for councillor itself goes, even though I have 2 months, 30 months in the president and vice president term, I cannot, my lord, get that benefit.
Now this 30 months is provided in section
42. 4211. Before that, your lordship may kindly see my lord Article 243.
But there is no dispute. 5 years term is 5 years.
Just wait, let him come.
Kindly see 43.
Just read.
43. duration of the municipality, every municipality, unless dissolved under any law for the timing in court, shall continue for 5 years. Kindly see the word use this continue for 5 years. Now they interrupted me, my lord, in the middle. 8 months is over. Continued for 5 years from the date of appointment of first meeting. First meeting is being the election for the president and vice president. The constitution does not permit, my lord, again for the second term, for second meeting, the president and vice president, president election for the president and vice president. Again I get it. No. Say first meeting is done, your term started. My duration starts from. So, my lord, now in 4211, what they did, my lord, for president and vice president, they divided into two parts, 30 months and 30 months. So, in every 30 months and 30 months, my lord, they have to provide reservation and conduct election. So, therefore, my lord, now your lordship may kindly see, my lord, section 315.
Section
315
of
municipality. Any general election to the municipal council under this act or any proceeding consequent thereof have been stayed by an order of a competent court or authority. So there is no stay order from any court. The election of all the councillors or more than 2/3 of the whole members of the councillors of the municipal council has been declared by the competent court or authority to be void. Then all the councillors or more than 2/3 of the whole member of the council of the municipal council have resigned. The state government shall, by notification in the official gazette, appoint an administrator for such place as may be specified in the notification and may, by like notification, curtail or extend either prospectively or retrospectively the period of such appointment. So, however, the total period of such appointment shall not exceed 6 months. My lord, first of all, I don't fall under my lord AB. And D, my lord, says even under AB, in the those circumstances, the maximum period, my lord, which they can appoint an administrator is for a period of 6 months. Now, my lord, 8 months is over. No steps are being taken. There is no stay. The councillor clause of the impression, my lord, that once again the election takes place for vice president and president, we will get to again 30 months. When they clarify that is not the position. Now, my lord, the councillors are before the.
But how are you going to resolve this now? Let us assume.
We will find.
Valid aspects. There is absolutely no questioning to that approach. The only prayer before my lord is maximum consideration representation to conduct election. Not for that we place on record numbers. There is no stay, but there are various directions to issue and we place on record. And we
Correct, but then the onus is on you now to get clarification before the apex. No, we'll give you a date, but we make it clear that unless you get a clarification, you may be constrained to consider his report. That's up to you. Now, in the event you feel that the SLP is going to take some more time, you can't keep them in the same position. You must seek for permission either to hold election for the.
With the removal of the orders of the Supreme Court, publicly to removal leading to when the matter has come up to the Supreme Court. I can see the order. You have heard the counsels for the petitioner in respect to petition. Each of them has stated the inspectors. Although the relief claimed before the High Court was accepted, the right petitioner would confine the relief and urge upon this court to mold it or to limit it to the concerned constituencies, town municipal councils, namely
Arsikere, Career, Koppal, Sidlugata, Senigiri, and Kerala. Therefore, my lord, it was clarified, my lord, it is only in respect of this amendment. My lordship may come to page 23 of this is order, my lord. It is 10/5/2022. There are other orders, my lord. Now, as of now, I am not 24 because in those orders, my lord, Supreme Court time and again directed, my lord, the state government to give it to NIC, and there was a reshuffling, all those things. There are certain orders. 23, my lord. Finally, these are the orders passed by the Supreme Court. The Learning Council for the state has invited page 25, my lord. Page 25. The Learning Council for the state has invited our attention to annexure R1, appended to the affidavit of Ajay Nagbhushan, MN Secretary to the Government, Urban Development Department, dated 9/5/2022, regarding the procedure to be followed for reservations of the office of President and Vice President in urban local bodies, as per section 42 of the Karnataka Municipality Act and Rule 13 of the Karnataka Municipalities Election Rules. The said document set forth the steps to be taken on the basis of which software can be developed by the National Informative Center, so that in future election there would be no issue about inconsistency or error committed in the preparation of reservation chart. The steps to be followed for preparation of such program is under. There are, as per the guidelines, the steps is described, and we said we have no objection for considering. Thereafter, my lord, the software, the worship, page 31. They have implemented it and they have said it has they have put all the reservations, and my lord, it is working and software is ready. That should kindly see, my lord, the report of the compliance at page 33. Mr. Surenso Learning Council appearing for the state of Karnataka has referred to the compliance report and points out that the authorities in terms of this court order have reworked the reservation constituency for the municipal council with aid of NIC. The exercise, however, will obviously work for the future election only. On the compliance report so far, the petitioners have no objection, but they would urge for hearing the special petition which relates to the election which held in the year 2020. Now, my lord, they have also, along with this affidavit, for the term, we are now, my lord, they are supposed to issue reservation in respect of 10th term. They have filed, my lord, after, my lord, reworking the reservations. They have also given reservation to the present term, that is the 10th term, which now they are supposed to issue the reservation for the 10th term. That is also they have prepared, and that is, my lord, affidavit they have filed. That is also produced. Page 60, my lord. Page 60. This is R10. Ninth term was under challenge, my lord. Ninth term was under challenge. After reworking, my lord, they have also given for 10th term. Because this thing is, we can't do anything for ninth term, which is already over. Future elections, we have already done it. Reservation is ready. I don't know why there is no state.
Now you get whatever it is up to you now. Now,
they will confine their reliefs only to Hassan, Arsikere, Adhikar, Koppal, Sidlugata, Changiri, and Kerala. And Lord, can kindly see when we issue the reservation notification, we issue for the entire state.
it will be interlinked. No,
But all these.
no, that contention we accept. It's all interlinked. You can't do it.
Six or seven constituencies, but all the other they have every office, state has not gone to the Supreme Court. It is appeal for private petitioners. They have gone there and they have reserved their liberty for these six constituencies. If these six constituencies, my lord, small affects for say that.
We accept your submission on that. Interlinked. But now since you have placed it before the court, and since it's also your duty to ensure that elections are held, you must get an appropriate clarification at your end. We'll have it on 22nd. It's the matter on 3rd. But you take it from me that I will proceed to pass orders unless it's now it's as much a duty on you to ensure that elections are. And you must show your bona fides. You must demonstrate your bona fides before the apex court that you intend to hold election for the. Let us see on the next day.
So that you know, I think that it is now you know as for 9 because the term is over.
Correct.
We wanted another SLP to look at this court. We have alternative ready to do this. For that purpose, we wanted to look at SLP. Other thing, because I am
No, the SLP, no doubt, but it has now crossed that stage, wherein you have given one software and it appears that that would be the procedure. So to remove ambiguity, you make an intervention and you seek for appropriate direction. Yes.
49.
Let us see, Monday we'll take it up.
Last date of hearing was the request is for a hearing. And we can
What is the construction?
and just submitting my business. And there is no sanction, there is no NOC, fire NOC commercial. And that particular commercial building is joined with my residential, and we have never consulted.
Government, you are required to clarify.
My lords directed them to clarify this.
Government, you are asked to clarify regarding the fire safety.
But even if an ambulance cannot enter, it is not a setback. The issue is that even not even the firefighting extinguishing machine, but ambulance cannot enter.
That we'll see. No, that we'll see. But
the same setback facts.
no, correct. But no, that is
They cannot file it.
no, that we'll see. But the government will have to plan. What happened? Monday. Now,
Let them not take any construction.
what is being constructed now?
They are putting up a pillar. They have picked up that particular foundation, and they are about to put the concrete. Once that is done, my lord, then where I will stand. And I will provide 3-4 days. And from 3-4 days, it will become very clear.
Solve the issue with the association. Till today, they are not been able to. Apart from the sanction plan, we have left extra 5 feet of setback. Apart from sanction plan, whatever to be left in as per sanction plan, excess of 5 feet is within. That means at least we can resolve the issue with the association, but they are not coming forward.
No, that apart, no, nothing prevents you from carrying on the construction, leaving that fire space. You can go ahead. The remaining
What
only.
we are saying is, we are not picking up anything state, construction in the plan. The entire building is constituted as one building. Around the building, I have to leave the 8 meter setback. They are telling for each block, we give you the front of their block, we will give the 8 meter. In the last, if the 8 meters is left back, what is left is, I have to give 8 meters and 8 meters, I left with the 3 meters to the construction.
No, just one now. Correct now. Have it on Monday, you put it in writing. Let the petitioner take it.
Let them put it in writing. my lord.
Correct,
This
let them put it.
statement is very,
Let them put it in writing.
yes, sir.
State-
This is very dangerous statement. Let
The,
them put it in writing.
the government to take the stand in writing. This is the matter on Monday. It's made clear that any construction made is, would be subject to orders to be passed by this court. We'll have it on Monday.
They cannot be engaged.
Monday.
With
Monday.
respect of fire, it is serious. And once the occupation is provided, my lord, it is also the duty of the occupant to ensure that fire requirements are complied with.
We'll see on Monday.
Yes. I have filed my synopsis of submission.
Then let us.
Yes.
I will provide.
Court fees to be paid. Why today? Today only you must pay. No, but now you can pay online, isn't it? Online. You can. This is the first time it's coming. You've given a copy to him. That will come later. This one. Just go to Annexus C, page 34. Site area itself is different. Then you see 1949, tenanted 1500. Tenanted is same. Then where is the difference? Non-residential. What is 2023? Let him appear before you. Sorry for this. They have not sealed or sealed. Let us see. Yes. Now, some in the newspaper, some scheme, some amnesty scheme, something. You place it, find out as soon. Same order. Petitioner to be present along with the tenants at the site on 12/2/2024 at 11:30 a.m. Whatever you say, let it be at the site, because if you have to do the measurement, why don't you do it at the site? Suppose you're going to do a measurement, then again there'll be problems. You do it at the site. 13/2/2024. That inspection must be done at the site. Otherwise, again, there'll be problems. In their presence. Next paragraph to be present. We format one change. The respondent BBMP to prepare a report after eliciting all necessary facts that would constitute ground for reopening self-assessment relating to the usage. The change. That is the same. BBMP not the order of attachment. There would be stay of the order of attachment and proceedings pursuant thereto till the next date of hearing. Deals the matter on
21st.
would fee to be paid forthwith.
Everyone?
Give him a couple. Give him. Page 42. Only with respect to applicability of zone. Let him appear before you and let him be heard. Same order. Petitioner to be present. With tenants details. Tenants are not required. But along with tenants at the site on 2024. What is BBMP is to prepare a report after eliciting all necessary facts that would constitute grounds for reopening self-assessment, including as regards applicability of zone. In the interregnum, BBMP not to take precipitative action. Now, what is pursuant to annexures? E1 to E6. Next week. To have it. It's submitted that an order of attachment has been passed consequent to the impugned orders at annexure E1 to E6. That is the interim order being passed. The order of attachment of removable property passed, stated to have been passed pursuant to the impugned orders is also stated. Subjection. Obvious objections to be complied with forthwith. But Council, I am making it clear in some matters after order of desealing has been done, petitioners are not appearing after the inspection report. If I find that, I'll be constrained to revoke the interim order.
Digital copy.
You accept notice. Now, who's AG accepts notice for respondent? 1, 2, 3. Fourth respondent? That Council Sri D. Nagaraj directed to accept notice for the fourth respondent. Office objections to be complied with. No, some sketch. His objection raised is kept in abeyance subject to the undertaking that at the time of hearing of the matter, if so required, legible copies would be furnished. Yes.
There's a virtual copy produced.
Office objection. The kept in abeyance is overruled in light of the submission that the annexure D and D1 are the originals. Same order, page 140.
142 annexure R.
Of the order at 142.
One to the end of the list, no matter what.
May I submit? May I request some? Malad?
Yes,
Next matter, serial number 54. Could your lordship have it after 16th, Malad? I was waiting because got 18. After 16th, I'll argue. Malad.
government has filed their objections.
Yes, Malad, I will be able to satisfy your lordship. Cheating has been done, the government is colluded. I'll address the arguments.
This is the matter on 19.
Grateful to your lordship.
I got wait in the morning. Next matter, yeah.
Good. Yeah. Okay. Other mentioning at 2:30.
Lords, with your kind permission, Lord.
Yes,
One matter, Advocate Abdul Ansar moved for 230, my lord. On behalf
Yes.
of him, I am submitting, and it's a BBMP matter, my lord.
yes. Just wait.
Uh,
Files are coming. I'll take it up. Just wait.
Lord. Lord.
Hearing matter, number 1, Mr. KM.
Same order. Sure. Big amount.
Property tax on 51 lakh.
You deposit something.
Not every variance, 21 lakh is a different property. But they have imposed interest, not 20 lakhs, penalty 52 lakhs. That's page 51.
That is something out of the, at least the tax component, something you can deposit.
And, one thing for that, 2016, 17, 17, 18, 18, 19. All the two data we have deposited.
That is. Same order. On 13 to 24. Not to take precipitative steps pursuant to
C and C series and D series.
C series and D series. And then the next date. Deals the matter on the right of the order granted as regards orders and demand notices. There would be stay of order at initially.
Number 2, Venugopal minutes.
Page 40. Give him a copy. Give him a copy. Share your copy. He's your lawyer today. Page 40. Now, the entirety of self is shown as tenanted. Otherwise, the measurement, there is no. So let him present himself. Right? We'll only say regarding the self and tenanted. That is the only thing, isn't it? So, but since when have you let it out?
Property has been seen.
Correct. But now you have been declaring it as self, but they are showing it as tenanted.
This did, it's a, F2G.
Okay. Yes, same order. On 13 to 24. Not to take any precipitated steps pursuant to annexures E, F2, G2, H2, and J2. Counsel for the petitioner submits. Premises has been sealed.
Yes.
How much you have paid after this?
66.
The petitioner submits. Pursuant to the it was demand notices. An amount of 66,000.
30,000 has been paid in the acknowledgement this year.
Huh.
Really, 33,000.
The 33,000 has been paid, and petitioner is depositing a further sum of 33,000. 110. Copy of the said demand draft
Yes.
is filed along with the memo. Accordingly, the respondent BBMP is to deseal the premises forthwith. Is the matter on?
Number 3. Within K.
Let me know the format. Show cause notice required. Actually, the counsel for the respondent BBMP submits that a perusal of the show cause notice may be necessary in order to find out the details declared in the self-assessment return vis-a-vis the stand of the respondent BBMP based on the revenue inspector's report. Accordingly, relist the matter in the orders list on 12th. In the interregnum, subject to further consideration, respondent BBMP is restrained from taking any precipitative steps pursuant to annexure H1 to H7. Why don't you make some deposit? But the amount is huge, you know. Petitioner undertakes to pay an amount of ನೀವು 2 lakhs ಅಂದ್ರೆ ಕೋರ್ಟ್ ಸ್ವಲ್ಪ ಆಡ್ ಮಾಡ್ತಾರಲ್ಲ. How much? Tell fast. 4 lakhs. 4 lakhs within 3 weeks from today. Respondent BBMP to is in the premises forthwith. ಪರವಾಗಿಲ್ಲ 2 ಲಕ್ಷ ಮಾರ್ಜಿನ್ ಇಟ್ಕೊಂಡು ಬಾರಿ. Yes. It's made clear that the amount paid is to be adjusted only to the lawfully determined tax liability of the petition.
Of the list move matter orders. Serial number 1 of the P.
appears for the petitioner, my lord, in this case.
Yes.
With regard to the tax, my lord, actually, I purchased it in the year 2020 and
ಇಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಬರೀ ಒಂದೇ ಒಂದು ಸಿಗ್ನೇಚರ್ ಹಾಕಿದ್ರೆ ಇಲ್ಲಿ ಈಚ್ ಫುಲ್ ಸೈನ್ ಮಾಡಿಲ್ಲ ಆಗ್ತದೆ ಅದೇ ಒನ್ ಆಫ್
There are large number of office objection. I'll consider it, but you have to clear them forthwith. I'll consider on
yes,
merits.
ma'am.
But
Yes,
it's
ma'am.
your duty to comply with the office objections forthwith.
Yes, my lord.
Yes.
Actually, I purchased in the year 2020, my lord. While purchasing, the entire tax liability has been paid. And after 2021-22, as on date, your lordship may kindly see annexure EFG. That and I declared as per the BBMP as in D zone. But what the claim of the BBMP is that I have declared as E zone and the non-residential area is 3,000 square feet. Actually, initially it was 1,500 square feet and 2022, 1,000 square feet was added. It was
Just one minute.
2,000.
Just one. Annexure H, page 48. Order, petition be present along with the tenants at the site on 13/6/2024. After the words and nature of usage, the BMP also to state in the report regarding the applicable zone. And usage ಬಂದಿದೆ applicable zone. BMP not to take any precipitated steps pursuant to the impugned
Annexure M, my lord.
the impugned orders. A stay of the order at the annexure M. And respondent BVP restrained from taking any action pursuant thereto. Within the next state of hearing. This is the matter on 21st.
Hand deliver my colleague is there.
It will be uploaded. It will be uploaded.
Memo, my colleague is there. He will give the memo.
No hand delivery. No hand delivery, but it will be uploaded.
Obliged.
On the
Obliged.
office of it to be complied with forthwith.
Obliged. Immensely obliged.
Number 2, and go ADR.
No, you're the owner. You're the owner or the tenant?
I'm the owner. Annexure A, my lord, annexure A.
Give him a copy. Give him a copy. Now, just share your copy. Just give him your copy now. It's 21. Page. Where do you get that measurement? That the difference is on the base of measurement. It's only the measurement. Now you deposit some amount that will be adjusted towards legally payable dues.
Demand notice, my lord. Penalty itself is concerned on the copy act.
Correct. You forget for the time being, for the purpose of deposit, you forget about the penalty. Insofar as the disputed tax,
Section A and B. A is demand notice, my lord, and section B is order, my lord. Both are dated same. Second order. That itself shows that there is no.
no, that we'll consider. But insofar as the disputed tax, you make some only tax.
Different taxes have come from.
Some
All I'm requesting, my lord, that there may be some reasonable amount that may be
use propose fast propose.
10 lakhs, my lord.
On 13th to 2024 at 11:30 AM. Not to take any precipitative steps pursuant to the demand notices. Annexure A1 to A7. As well as the orders, annexure B1 to B6. The counsel for the petitioner undertakes to deposit remit with the respondent BB MP an amount of rupees 10 lakhs within 3 weeks. Respondent BBMP to deseal the premises forthwith. There are a large number of office objections. Your prayer is wrong. That you have to, I'm giving you liberty. Correct your prayer here. A1 to A7 are the demand notices, sir. But you have said orders. In column B, it should be orders. You put demand notices. Petitioner is permitted to rectify the prayer column. And you, office objection, you must do it forthwith. Office is raising a lot of grievance with the lordship. Correct, but correct. Once we give, you must also reciprocate.
What is challenge in this method? Only proper the properties are not seen, my lord. There's no order or demand of the my lord in this. So I'm saying that if
Page. BJP not to take precipitated steps pursuant to A2A3. The measurement, lot of discrepancies there. Measurement. Your it's 10, what you have declared, 11,000.
Will demand these and all. Absolutely not forthcoming. What is it? Just randomly is sat down and calculated.
Yes. Court reserves liberty to impose suitable condition upon receiving of the report. With objections to be complied with forthwith. Yes, yes. Okay.
So one, also reminder, serial number 2, Kalyan R.
Para number? Yes.
Assessment year, right? Assessment year 16, 17. 1890. For the assessment was done and tax was paid on 11/6/2018.
7/6?
11/6/2018. Now we got 18 or max.
Beyond 5 years.
Yeah.
So we have to include 18, 19.
18 in that.
That's all.
That's all.
Counsel for the petitioner. Right. Petition. For certification of the order, stating that in para 3, considering the contentions raised and the regards limitation provided for under 144 clause 16, court ought to have included the relating to the year 2018-19 as well. Taking note of the submission and contention advanced, which requires acceptance after the years 2016-17 and 2017-18. The para 3 of the order, years 2018-19 to be inserted. In the order dated 2024. The order is rectified to such extent and IA is disposed of. Sign the application. Sign much. Yes.
Matters, this number 1, hearing B2, serial number 56, Mr. Dasuraju.
Yes. Has been? Correct, but it's the matter. To say. The government advocate to take stand as directed by the next date. Advance copies to be served on the other side. They will have to have a look at your stand. The order earlier granted is extended till the next date. Learned counsel for the petitioner submits interim order was not extended due to bona fide lapse on the previous date and has filed a memo seeking extension. In light of the same, interim order earlier granted is extended till the next date.
Yeah. Ramachandra?
Ramesh Chandra.
Ramachandra?
ಒಳ್ಳೆ ಹೆಸರೇ ಕರೆದಿದ್ದಾರೆ ಬಿಡಿ.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಇಲ್ಲ ಅದು ಇಟ್ ಈಸ್ ಆಕ್ಚುಲಿ ಮ್ಯಾಚಿಂಗ್. ರಾಮಚಂದ್ರ ಅಂತ ಹೇಳಿ ರಾಮನವಮಿ ದಿವಸ ಹುಟ್ಟಿದ್ರಿಂದನೇ ರಮೇಶ್ ಚಂದ್ರ ಇಟ್ಟು.
ಎಸ್.
ಏನಿಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ petitioner's mother purchased the property on 27/9/95. Subsequently, mother died. Then it went to father's name, and father's name subsequently father died on 23/1/2012. The petitioner obtained plan and license for putting up construction on 3/10/2013 by the Gram Panchayat. Hebbugodu Gram Panchayat. You lost my kindly see the page number 37, D1.
That is a license.
Plan, license. Plan is also there, my lord.
Yes.
Plan is also there. What happened, subsequently it has become municipal corporation, Hebugodi. They have started issuing notice at the instance of the neighbor who says his property is encroached. Then the annexure A may kindly be seen. The annexure A, the Hebugodi Panchayat Nagar Sabha says that Panchayat had no power to grant license for plan and license for the construction. That is why the order was passed. This honorable court has stayed it and subsequently permit me to put up construction. Now construction is complete, my lord. I have started construction during 2013. It was not over because it was a 4-story building.
The other side is not there. Let us see. We'll take it on some other day.
They are not coming, my lord. It was, that's why several times it was made such an order. Subsequently, another council was appointed.
So is he in the panel now or some change?
Now, the panel change, ma'am. Earlier, Basraj was.
City Municipal Council, Hebugodi.
Yes, my lord.
Bangalore Urban.
Now Tippeswamy is appearing.
If he doesn't come on the next date, we'll ask the present panel council to find
No,
out. Make
present panel council, my lord. Earlier, Basurajappa was there. Then he was taken notice.
representation on behalf of the respondent. This is the matter week after next. What did you put in? Hebugodi. The Municipal Council, Hebugodi.
Okay.
Where my name board.
Why was it adjourned last time? No, but we are on tax, isn't it?
on taxes. The judgment do not apply because that is specifically for sky sign. I am not a sky sign. I am a name board. Name boarding are exact judgment apply.
Let us see, you just tell us what it is. Paragraph? Paragraph? No, correct. Now, getting a permission, of course, that's his headache. Suppose in terms of this he has to get, That's it. But now, what is raised in the present petition is one of tax. That is that has to be dealt with separately. In terms of 265, you have to show authority of law. Now he says it falls outside. That means now We'll have it next week. Have a look at what those.
So I just want to try to see
Yes.
that there are actually three judgments. There are two judgments which have held that you can't impose the competitions. One judgment which holds other. So the other judgment also, just so that my friend also has it, he only has given me the judgment.
It has taken a contra view.
But actually, I think one has to read the section very carefully because the contra will apply for the sky side. My lords have the act with and explain why
Which act?
the Karnataka Municipal Corporation Act.
2020 or the old one?
1976. 1976.
Now, what has happened to the new act?
These are the proceedings under the old act. New act more or less material carries the same.
Yes.
134. But see the tax on advertising. Every person who erects, exhibits, fixes, or retains upon or over any land, building, wall, or structure, any advertisement, or who displays any advertisement in public view in any manner whatsoever, in any place, whether public or private, shall be on every advertisement which is so erected, exhibited, fixed, retained, or displayed in public view. A tax calculated in such rates and in such manner is subject to such exemptions. First provision, second provision, third provision. Provided that no such tax shall be levied on any advertisement which is not a sky sign. Not a sky sign is what is very critical here because in the facts of this case, the coordinate, the first judgment which my learned friend referred to, in that particular case, it was a hotel. On top of the hotel, they put a sky sign saying that we have a banquet hall. This is our banquet. That was the facts of the case. Here, members, sky sign illa andre, members, under the Shops and Commercial Establishments Act, I am required to put up a board in equal size. Englishally, Kannadalli. It has to be an equal size, saying that I am so and so establishment. So, members, if I am a hotel also, I am supposed to display the excise license. That members are statutorily prescribed requirements. For statutorily prescribed requirements, members, this exemption is squarely applied. This exemption is exhibited within the windows of any building. That is the first thing. So that and is relates to land, relates to trade or business carried on within the business upon which or over such advertisement is exhibited, any sale, lettering, so and so, or meeting to be held in that business. Explanation 2 relates to sky sign. What they see the expression sky sign in this section, explanation 2. Sky sign means any advertisement supported on or attached to any post, pole, standard, framework, or other support structure, only or in part over any land, building, wall, or structure, which any part which shall be visible against the sky from some point in any public place and includes all and every part of such pole, post, standard, framework, or other support. Expression sky sign shall also include any balloon.
So this you are saying this is not a case of sky sign.
Yes.
And the case earlier relied on by them was relating to having sky sign without permission. And if the bylaw is taken, which provides for a penalty of payment of tax similar on par with that of commercial, that is with respect to unauthorized sky sign. And this you can't extend.
This is not a sky sign. And that is coordinate basis. And if that is the only way to reconcile the judgment because we're not going to see the other judgment which I just passed on.
Yes.
Let's read from para 2.
Yes.
learned counsel for the petitioner submit that in all these cases, the contention of the petitioners is that they have not put up any hoardings or advertising. They have merely displayed the name boards of the shops, restaurants, trade business that is being carried out in the premises. Attention of this court is drawn to clause B of so and so minutes. Then the Hutchinson SR is referred to. Then they refer to two other judgments. Ultimately, minutes. Paragraph number 6 minutes. Having regard to page 20. Having regard to such contentions, this court came to a conclusion that the decision in the case of Vasudev Bhatt applies to all courts of the same reasons, findings and conclusions. It was held that the petitioners are entitled to exemption from the payment of advertisement tax in terms of the third proviso of section 154. This court has gone through the material available on record in each of the petitions and finds that the petitioners have put up name boards on the premises which would clearly attract the exemption clause contained in third proviso of section 34. This court is of the opinion that the issue demand notices could not have been issued to the respondent assistant revenue inspector and BBMP. Consequently, it is now the Lord will kindly take the judgment which is now referred to, that is the latest judgment.
Yes.
WP 42403. Second paragraph. Petitioner claims to be a hotel established in the year 2008. Petitioner further claims that the petitioner had put up display boards containing the words Numa banquets, corporates, and weddings, which is only a self-advertisement. As such, the same is the So, whereas this was a case of an admitted advertisement, which is executed under permissible under clause B of provision B of section 134, for which no particular permission is required, taxes are exempted. When being the case, the respondents on 24/9/2016 possibly raised the display board, put up on the premise of the section of the law that property tax is not being paid, and the notices have been issued have not been. It is challenging the notices and the raising of the advertisement board petition is before them. But paragraph number 4. Sorry. Paragraph number 3. Also, the petition submit that it's a non-emulating holding which is fixed on the compound wall of the petitioner and also as a unipole has been fixed. Notice, I'll read the definition of sky sign to fall within that definition. And fixed on which only the name of the petitioner has been shown as self-advertisement. The words used in the advertisement, the banquets, corporates, and weddings, is only as regards the services which are being offered in the building, and as such, it will come within clause 24 of Rule 2 of the advertisement bylaw, which deals with name boards, whether illuminated or non-illuminated, displaying only the name and address of any commercial business or social activity that is being carried out in the same premises. As such, this self-advertisement has been defined in the bylaw and is exempt from tax under provisos so and so of 134 Act. On this ground, it is submitted that there is an exemption granted. The question of whether there is a violation part of the petition would not arise. Commission of Budget, learned counsel is that bylaws cannot override the act and seeks to allow the petition.
But here the challenge was only to the raising of it. The challenge,
Raising as well as the demand notice is also challenged.
But here they say that you have to take permission.
It's a self-advertisement. How does one understand advertisement? That becomes the issue here. Putting up my name, the name of my business, if whether I put it as Future Retail Private Limited or if I put it as Aditya Birla so and so, that may not amount to a advertisement.
The permission one, but whether it is a whether tax can be levied is the other. Correct. In case you have not taken permission. But so that's only by default it comes in. Because you have not taken permission, accordingly you have to pay tax as commercial. That's how it proceeds. But here the question of permission is not an issue. Correct. So the question of tax and exemption is what they're claiming. But in that case, because they had not taken permission, hence in terms of 4F, they're required to pay as same as in commercial. That's how it has proceeded. But you bring the bylaws, let us see.
It has been insisting for connecting.
No, let us see. Now you get the bylaws. Deal is the matter. Short date for next week. Huh? That's okay. I won't be there for that matter. No, let us see. No, let us see if it is possible to have that you make out a case whether it can be distinguished and the facts of that case, you look into the facts of that case, whether that case relates to non-taking of permission and hence according as a penalty, 4F comes into play and because of 4F is ipso facto direct required to pay as commercial. Whether we can, if what are the facts of that case and whether that was the issue. If that was the issue, in that context, we'll only say what has been dealt with is because you have not taken permission, you have to pay tax at commercial rate. Whereas here it's different unless you say the notice here is not on the same basis.
Self-advertisement means just saying your name is so and so itself of self-advertisement. Then respectfully, that would defeat the provisions of the exemption. The exemption is meaningless. If the interpretation which is sought to be given by the learned friend, that the moment you put your name there, the exemption becomes meaningless. The moment you put your name and the definition of self-advertisement is advertisement means that exhorting somebody to buy something. It can't be that you can negate the provisions of the exemption by reading an extraneous document.
You place also the requirement on Shops and Commercial Establishments Act, which mandates that you have to display. So if it is something that is statutorily mandated, that cannot be deemed to be an advertisement. What's your argument?
That is what strength of that exemption.
Let us deal is the matter on next week. 15th. On 19th. The third floor is without sanction plan is some observation.
challenge with the lordship is A, R, possibility that A, that's it. A, 3 0. Order in 370 for 246 greater than 16. Another is one to 15 9. Where from the letter A, B, number 35. And the temporary order of the respondent has specifically stated that the appellant has constructed.
You're reading at page?
Page number 359.
Yes. Yes.
The temporary order of the respondent has specifically stated that the appellant has constructed the CAD floor over the existing building without obtaining any license or tax to the respondent. Thereafter, the land AAT confirmed the order after the building. The whole issue is the land city. I mean that it is an unauthorized construction. Not unauthorized construction. I only see hardship intervention at annexure C, A16. The government notification exercising the statutory power in the section capital of Karnataka ordinary and the following list of road identified road winding for granting T. I see a number. My lordship, once the TDR, that is notified the public purpose. Wider public interest involved. I don't know where I. If you have my portraying these 20 feet road widening, I am entitled to put up 1.5 times of additional. That's it, AC.
Now the property is in which road? Now the widening has taken place. No.
If the road widening has taken place, TDR has issued, I am away. But only notified, I have anything. Not the attention of God. It's a E.
No, but no, correct. So, but are you saying that in the event of road widening, you would give up that amount?
That's why the longer you there is, classically you see a connection 9, annexure is 90, annexure D. Then 90, how the government has given this benefit of the development of right section 14B.
No, just 1 minute. Now he's making an offer stating that if you were to widen Avenue Road, he's ready to give it up, whatever area for the purpose of road. And then he's entitled for TDR that may be taken note of for the purpose of adjustment of what is it. You examine it. You find out. Get. No. If you find out from the authorities, if we are ready to accept and he's ready to give up, then we will see how relief can be molded. You get instruction. Learned counsel for the petitioner submits that in terms of the notification at annexure C, Avenue Road has been notified under section 14B for widening with an offer from respondent BBMP to grant TDRs to the affected landowners. Submitted that the petitioner is willing to give up property for the purpose of road widening and accept TDRs in lieu of cash compensation. It is submitted that if that were to be so, the property of the petitioner stated to have been built contrary to sanctioned plan could be regularized taking note of the TDR. The counsel for the respondent BBMP to take his stand regarding the same. This is the matter after 2 weeks. You find out and put it in writing. the counsel for the respondent to take stand in writing regarding the same. Yes.
60 again, number 61. Everybody know?
ನಿಮ್ಮನ್ನ ಏನ್ ಮಾಡ್ತಿದ್ದೀರಾ? ಇದು ನೋಡಿ, urgency ಕೇಳಿ, last people ಕೊಡಿ.
Yes.
There's a notice. Should be helpful. The board is not submitted.
The master plan.
Commercial competition, which is running going on in that road. That was as the direction issue that
The PIL 3676. Yes.
These roads is commercial.
It's come out, is it?
They are paying property taxes today. So now as of now, today they are all functioning. Establishment. Action taken against them. At that point of time, they had given a representation to the council for the existence of shut. The BPMP council committee. Pending before this committee. Has taken over in that. Commission they don't have yet with regard to any action. BPMP is proceeding against any person, petitioner. So, they are all functioning as continue to
So
function.
what you do, the 2032 proposal, you place it on record. We'll record that and close it. When do you want it? It's the matter on 19, not 19, 20th. Yes. Yes. Yes.
62 with the respondent.
It is there, put on the website, is it? Yes.
Applicable to this.
62 with the respondent.
Up to next. Yes.
63, Subhash PG.
Not going to be tried before. This night is thought by by creating a document. Enclosed on the road, which is earmarked in the map. In that area, yes, every border. So there was a giant inspection of the original authority. They have contacted the Maza and they have taken position at the border and directed the panchayat to take to the border. That card is no challenge.
Have it next week, get ready on the main, we'll finish. Is the matter on? If. Other matters will not be taken up. Interim orders in operation will be extended in the next day. List along with the WP. And 80 of is along with WP 6206 of 23.
ಡೀಲಿಂಗ್ ಮಾಡೋದಕ್ಕೆ ಆಲ್ರೆಡಿ ಒಂದು ಆರ್ಡರ್ ಕನೆಕ್ಟ್ ಆಗೋದಿಲ್ಲ ಡೀಲಿಂಗ್ ಒಂದೇ ಒಂದು ಇಷ್ಟ ಆಗಿದೆ ಯಾಕೆಂತ ಇವತ್ತು ಒಂದೇ ಒಂದು ಇಷ್ಟ ಆಗಿದೆ ನಮ್ಗೆ
Just along with WP 6206 and 8055 of 23. Dates are not available. Huh? Week after next date. It's the matter in the first week of March. Yes, yes. From this side will go. Yes. Six. It's the matter. Yes.
What officer, sir? ಅಲ್ಲ ಹೇಳಿ. ಹಾ